Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. This is Calum Cheyne. I'm Luke Zadkovich.
Every episode, we read a case independently of each other. So jump on the podcast, we hit record. So what you get is our raw thoughts on that law.
And we're super excited with some of the guests we've got coming up on future episodes. So keep an eye out.
And if you like the podcast, all we'd ask is that you hit subscribe and share with your network. Okay, let's get into it.
Let's do it. Welcome to Case by Case. This is a podcast brought to you by Calum Cheyne and Luke Zadkovich from FZ. How are you, Calum?
Very good, Luke. Very good. How are you doing?
I am good. I'm in a good mood. Just knocked over an English Comm court trial. I can't talk about it. It's one of those private ones. But it's been a hard slog. But getting back onto the podcast next day.
3-day.
Yeah, 3-dayer. It was a good solid debate, let's just say, and hopefully find out soon how it all went. So that was good, and very excited today to welcome one of our colleagues, Derek Yixin, an associate here at FZ. How are you, Derek?
Yeah, not too bad, Luke. Not too bad. Thanks for having me on today. Really delighted to be on with you guys.
Cool. Yeah, and we've got an interesting case to kick around today. It is. I think I'll just knock out the citation straight away, Calum. This is the CAFI, Commodity and Freight Integrators, on one side as the claimant, and GTCS Trading as the defendant. It's an appeal from an arbitration. Actually a GAFTA arbitration that went through the 2 layers of GAFTA arbitration and it's now found its way into court. So it's the High Court of England and the Commercial Court. It's a decision of the 3rd of June this year, 2025. The citation number is 2025 EWHC 1350 Comm. And it's a decision of the Honourable Mr. Justice Henshaw. Few grounds of challenge in this one.
Rare to see, all 3.
Yeah, all 3. We got 67, 68, 69 for the trifecta.
Exactly, two challenges and an appeal, which is exciting and also successful on all of them. Spoiler alert, but that's the way the wind's blowing on this one.
Okay, well we've done that. Thanks for your time, Derek. What did you make of this one, Derek? Do you want to map out some of the facts and tell us a bit about it?
Absolutely, Luke. And I just want to say this case is actually really exciting because it apparently is one of the first reported cases of a challenge succeeding on all 3 grounds, 67, 68, and 69. So this is really a once-in-a-lifetime case.
There you go. I did not know that. My excitement levels have risen even higher than they usually are, which I think I say at the start of every episode I'm excited. But it is true. I genuinely enjoy these sessions that we have. Challenge on all 3 grounds. What kind of contract are we talking about here, guys?
Yeah, so this dispute really revolves around 2 sales contracts, but for the same cargo. So essentially, the parties entered into a contract for the sale of Russian milling wheat to be delivered from Russia to Egypt. So the buyer in this case is CAFI, which is also the claimant in this case, and the seller is GTCS, which is the defendant in the High Court case. So essentially, while the vessel was en route to Egypt, CAFI informed GTCS that it was having difficulties making payment due to US sanctions against Russia. And on the vessel's arrival in Egypt, GTCS attempted to terminate the contract actually on grounds of anticipatory breach on the basis that essentially the buyer wouldn't be making payment because of the sanctions issues. So there was some discussion between the parties, there were some negotiations, and what appeared to happen is that the parties agreed to cancel the original contract and enter into a new contract at a lower price. So essentially a second contract was then entered into between CAFI and GTCS. And in that new contract, there was a new clause that was inserted called the termination clause. And the termination clause essentially stated that the first contract would be terminated and considered void.
And it looks like what's happening here is there's this attempted sale. Under that first sale, the buyer says, I can't make payment. I'm stopped. I can't do it. There are sanctions issues preventing me from making payment. The seller then says, well, in that case, that's a repudiatory breach. The buyer says it's not a repudiatory breach. I'm entitled to certain contractual protections in circumstances where I cannot pay. And they agree this new contract, which kind of, it, as you say, it forms a part of almost the same sale, but it's this new contract which appears to document some kind of compromise based on all of the back and forth that they've had so far.
Yeah, that's correct.
Yeah, so we've got two contracts we're dealing with, right? And I think they call them the first and the second contract. And as we're going to get into, each of those contracts have their own jurisdiction clause. They both call for GAFTA arbitration. So we're dealing with an arbitration agreement in each of those contracts. And then, one of the key issues that arises in this is the scope of the arbitration agreement in the first contract and how that may be impacted, if at all, by the second contract. So you're going to hear us talk about the first contract and the second contract and the arbitration clauses in each of those contracts and how they interact with each other. And I found this quite an interesting concept, is when you have an arbitration agreement in two separate contracts, how do they interact with each other, if at all? If there's overlap, what does that mean? And of course, this decision that we're dealing with here, that's now got into the commercial court on a few bases, stems from an arbitration under the first contract. So there has been an arbitration commenced under the second contract, but that was stayed. It was also commenced later in time after, I think, the original decision in the arbitration related to the first contract. But what we're looking at here, and the prism through which this analysis is taking place, is what is the breadth or the scope of the arbitration agreement in the first contract.
And the reason that the second contract then comes into it is that the second contract is where you have this provision which purports to terminate the first contract. So you have a party under the first contract saying we are entitled to something under this contract, and a party which is then saying, well, under a second contract, you have prejudiced your right to that remedy, and we're entitled to rely on our contractual rights under the second contract in the arbitration commenced in respect of the first contract, which gives you this wonderful overlap between arbitration agreements and whether the tribunal that is appointed under the first contract also has jurisdiction to deal with a defence really that arises under the second contract.
Yeah, exactly. Were there any other particular facts that you wanted to go to, Derek, on this in terms of the clauses or the dates or the contracts? It might be worth mentioning briefly what happened in the first tribunal's decision. But any facts you wanted to touch on before we get into that?
I think those were the key facts that was very helpfully covered. And I think in terms of the approach of the two different tribunals, obviously this case went first to the first tier GAFTA tribunal. And it's interesting that the first tier GAFTA tribunal and the appeals tribunal, they actually took quite a similar approach in terms of the jurisdictional question, but they obviously reached different results. So in the first tier tribunal, essentially, the claims of GTCS was dismissed. So GTCS brought claims under the first contract commencing arbitration, and they sought damages for repudiatory breach of the first contract against CAFI. And essentially, in the first tier tribunal, on the issue of jurisdiction, the tribunal considered that it did not have jurisdiction to consider the second contract, as the second contract fell outside the scope of the arbitration agreement, which relates only to the first contract. So it made a distinction right away that it did not have jurisdiction to consider the second contract.
So this is a case where the seller is saying, under the first contract, I'm entitled to be paid. And the buyer is saying, under the second contract, we have cut through your right to be paid. We've terminated it, it's cancelled, it's gone, the right no longer exists. And the tribunal in the first tier GAFTA tribunal is saying, we can only look at the first contract. The first contract says there's a right to be paid. The second contract is irrelevant for our purposes. We have no jurisdiction to consider what it means. We're just going to say you have a right to be paid.
Essentially, yeah. And the tribunal does an interesting thing where basically, although it says that determining, for example, the legal effect of the second contract is outside the scope of the arbitration, it does go on to basically consider that the termination clause that was inserted in the second contract is considered as evidence that must be considered in the current arbitration. So it's an interesting little distinction that they make, that the termination clause can be considered as evidence, but they don't have jurisdiction to determine the legal effect of, for example, that termination clause.
Yeah. And then, how is that? How does the second tier tribunal deal with that differently?
So essentially, in the first tier tribunal, on the jurisdiction issue, they obviously held that the second contract was outside of the scope, and basically they accepted that under the termination clause, there was an intention by GTCS to waive their claim for damages by entering into the second contract. So the claim was dismissed essentially in the first tier tribunal. The appeals tribunal took a different position in terms of the final result. So on jurisdiction, similarly to the first tribunal, the appeals tribunal held that it did not have jurisdiction to interpret the terms of the resale or the terms of the second contract, but the terms of the second contract remains good evidence of what happened post-termination for the first contract. And on the issue of waiver, for example, the appeals tribunal differed from the first tribunal and held that GTCS did not waive its right to claim damages by entering into the second contract, and that it wasn't an indication of waiver. So it's on that point, essentially on the merits, that the appeals tribunal took a different result.
Yeah. And then this ends up before the High Court, and a lot of our listeners will be familiar with the route by which an arbitration becomes a High Court case in England and Wales. But to summarise, there are three different grounds. Two of these are challenges to an award, and a challenge to an award is something that parties cannot derogate from by their agreements. It's an English law right that you have if you're in arbitration governed by English law. Which is to challenge an award on the grounds that the tribunal has done something irregular or that the tribunal has no jurisdiction. And those are your Section 67, Section 68 grounds of challenge. And then you'll have a Section 69 ground of appeal. And an appeal is something which parties can opt out of. And actually in a number of major arbitration institutions, by agreeing the terms of the arbitration institution, you do opt out of your Section 69 appeal. But a Section 69 appeal is where you say the arbitration got something wrong as a matter of law, and here we get all three. So maybe Derek, talk us through what are the two challenges in this case, and what's the appeal point?
Yeah, absolutely. So I think the two main challenges here is really under Section 67 and under Section 68. So 67 relates to jurisdiction, and essentially what the High Court held in the case is that the appeals board actually did have jurisdiction to consider how the termination clause in the second contract affected the rights of the parties in the first contract, including any issues, for example, of waiver. And it looked at the scope of the arbitration agreement in the first contract and held that as a ordinary interpretation of disputes arising under the contract. That was wide enough in terms of the language to capture disputes around how the parties rights under the first contract would be affected by entering into, for example, a second contract. So it just held that the scope was wide enough to capture the second contract, essentially.
So there's a point there, which is the parties could have commenced arbitration on this decision. The parties could have commenced arbitration under the second contract, under the arbitration clause in the second agreement or the first agreement. Is that the effect of this?
Yeah, I think that's right. I think the court here identifies that there's an overlap between the two arbitration agreements, and that there may be certain types of claims that are brought under the first contract which properly fall within that arbitration agreement, but it includes issues arising under the second contract, and some of those issues could also be dealt with, albeit it may be framed in a different course of action or part of a different defence, as arising under the second contract and subject to that arbitration agreement. But it definitely contemplates this concept of an overlap. And just because it's not like the court has to decide, is this an issue that falls on that side or this side? There are issues that can come up in different ways under each of those arbitration agreements.
Because you could have two competing tribunals.
Yeah.
One appointed under the second arbitration, or under the second contract's arbitration agreement, and one under the first arbitration agreement, which would lead to a slightly odd situation where you would have to navigate the possibility of having two validly formed tribunals being asked the same questions.
Well, I think you have to ask what are the causes of action that are being pursued under each of those contracts. I could see how like a defense to certain actions under the first contract could be framed as a claim perhaps under the second contract or some other kind of formulation of it, but I'm not sure it wouldn't be exactly the same claim. There'd have to be some kind of different formulation, but I can definitely see the overlap and the point you're making there.
And I guess the point there is the argument here for the seller, which is you should be very strict and you should only really, I guess the principal argument behind it is you should only really be able to commence arbitration under one clause. You shouldn't be able to commence arbitration under two separate agreements for the same thing. Is that maybe that's in principle a neater approach?
It's a neater approach, and it's also aimed at avoiding inconsistent decisions, right? Yeah, so I see that, but I think if we take a step backwards and look at some of the general principles of construction on jurisdiction clauses, I thought there was quite a helpful section here to frame the discussion at paragraph 35. And this is a quote from Dicey, Morris and Collins on the conflict of laws. And essentially there's a number of familiar principles of construction in dealing with jurisdiction clauses. I just thought it might be helpful to read a few of these out. As a sidebar, coming out of court the last few days, it was really interesting hearing leading counsel making their closing and indeed their opening submissions, in that there was a big difference between a more kind of structured way of presenting arguments with numbered lists. And I could see here in this decision, you've got the 8 points or 8 principles to consider in looking at a jurisdiction clause. Absolutely nothing to do with the case. But yeah, anyway, so sorry?
Love some numbered paras.
Numbered paras, yeah, exactly. And it just frames the whole argument in oral submissions and makes it much easier to follow. So number 1, jurisdiction clauses should be construed widely and generously. And by all means, jump in on these guys if you think you've got some comments on them. And number 2, an agreement which is part of a series of agreements should be construed by taking into account the overall scheme of the agreements. I think, and the reason I'm kind of going to these is I think it goes to your point here, Calum, is that it's not just a case of, let's look at each of the arbitration agreements in isolation when there's 2 contracts. You do want to look at the overall scheme here and what the parties were looking to do with these multiple contracts. Point 3, it is generally to be assumed that just as parties to a single agreement do not intend, as rational business people, that disputes under the same agreement be determined by different tribunals, this is your point. Parties to an arrangement between them set out in multiple related agreements do not generally intend a dispute to be litigated into different tribunals. 4, where there are multiple related agreements, the task of the court in determining whether the dispute falls within the jurisdiction clauses of one or more related agreements depends upon the intention of the parties as revealed by the agreements at the time when they were entered into, as against these general principles. Now I think it's worth pausing there, because that issue arose here in that the first contract had been formed, and then things happened after that contract. And there's some discussion around whether you should be looking at what happens post the first contract in construing the scope of the first arbitration clause. And that's it's a tricky one there, because you can enter into a subsequent agreement that waives, terminates, does something with rights that had accrued under the first contract. But in terms of construing the scope of the arbitration agreement. It's not immediately apparent to me why what happens afterwards is relevant at all.
Yeah, you would ordinarily be looking at the construction of an English law contract through the lens of the parties at the time of entering into it, rather than what happens subsequently.
Exactly. Point 5, rational business people are unlikely to intend that disputes between them should fall within the scope of 2 inconsistent jurisdiction clauses. 6, what is required is a broad, purposive and commercially minded construction in the light of the transaction as a whole, taking into account the overall scheme of the agreements and reading sentences and phrases in the context of that overall scheme. 7, this may include inquiring under which of a number of interrelated contractual agreements a dispute actually arises, and seeking to do so by locating its centre of gravity, and thus which jurisdiction clause is closer to the claim. And 8, nevertheless, the normal process of construction may not be able to avoid a degree of fragmentation and overlap. And so I know that's a little tedious to go through all 8 points. Nonetheless, it does go to the discussion we were just having. It's not a simple case of does it fall in one contract under the arbitration agreement, one contract or the other, or can it be in both? You have to look at more than that. There's more that goes into it.
Because the commercial, the breadth of the commercial adventure is going to be, or can often be, broader than just one contract.
Yeah.
So it makes sense to pull other issues into an arbitration agreement, and I think that's what's going on here. And I think, well, certainly according to the High Court, this is where the GAFTA tribunals simply got it wrong, to say, we're happy to essentially excise the second our ability to comment on the position under the second contract, because we're just not entitled to, and I suppose it then almost follows naturally that the both challenges have to succeed.
Yeah, I mean, I think it's an interesting point that you raised, Calum, earlier about the conflict. Obviously, where there's an overlap, let's say, for example, the 2 tribunals reach different results on the interpretation of, let's say, the termination clause in the second contract. To what extent is that, able to be resolved afterwards? If one tribunal says that the termination clause, has a certain effect and the second tribunal disagrees, they're both validly constituted, where does that take the parties afterwards?
I mean, presumably in that situation, you run into issues of issue estoppel, and those kind of, I don't know which exact one you would use here, but you've got your kind of abusive process, res judicata, issue estoppel, those kind of arguments where you would be saying you would have to be arguing that one of the tribunals or the parties in pursuing one of the arbitrations was in some way that was an abusive process.
Is it a question of who got there first in terms of which award was rendered first, or is it a question of which tribunal had more authority to interpret that particular issue? For example, the second tribunal might, an argument could be made that they had more authority to interpret the legal effect of that second contract because that was the contract under which they were constituted. So, I mean, I think it raises complex issues here when you have real potential of conflicting awards when the jurisdiction obviously overlaps.
Yeah, and you can see this arising in the context of a contractual dispute and then a settlement agreement thereafter, right? Where you've had a contract entered into years before, some dispute arises, there's a back and forth between the parties, and ultimately the parties decide to settle their dispute, and then they enter into a new contract with a settlement agreement, right? And in some ways, I suppose that's what this is. They then the settlement agreement was in the shape of further business, right? And we see that regularly. The parties will settle a dispute by giving a discount on the next trade or what have you, and then I think you're right, Derek, in that it seems kind of obvious that you would then look to the later in time contract to see what the parties had done to kind of resolve the earlier dispute, rather than going back to the jurisdiction of the original contract, which is this settlement superseding it to say, well, do we still have a claim under that? Yeah. So
in a way, that's maybe the mischief here.
Yeah.
Is that the seller has gone under the old contract, the sort of dead contract, if you like, and said we're entitled to be paid under this contract, and you're not entitled to argue that we're not because that's subject to a second agreement. And I think if you look at it through that lens, the seller's arguments become quite unattractive commercially, and that's probably why the court was keen to and able to find as it did that you have to consider the second contract. The tribunal has to be able to consider the second contract, and whether that's a matter of jurisdiction under the Section 67 challenge or a matter of the proper conduct of the tribunal under the 68 challenge to hear both parties and to say we're going to listen to your defence and your defence arises under this other contract, or even as a matter of law. That's probably why you have this challenge/appeal that ends up succeeding in all three.
I think you're right, because if in that scenario where you kind of make it very clear that rather than first and second contract, you think about it in terms of original contract and a settlement agreement, and then one party says, "Well, you didn't settle it properly. You didn't release us from claims under the original contract. Yeah, we entered into a settlement, but that's additional to what you still have to pay us under the first contract. We're going to go commence arbitration under the first contract." You can see this is your point, Calum, isn't it? That in that situation, you would want that tribunal constituted under the contract to be able to say, "Well, hang on, you've settled it, you've resolved this, like you've released them from these claims. Well, what are you doing here?" Rather than ignoring completely what happens next and just saying, "Oh yeah, there's still a claim under this contract."
Rather than having their hands tied and saying, "Well, we can't determine whether the settlement agreement actually settles this, so we're going to say that you're paid under the first one and leave the second agreement for another day." Where do you come out on this one, Derek? Have we got the right answer in the High Court? Or are you with the GAFTA?
No, I think the High Court did reach the right decision on the jurisdiction point. And I think, it's interesting, it was brought up in the case that the GAFTA rules are actually quite unique in that they allow for concurrent hearings to be held in respect of more than one arbitrations. And that's the case even without the parties' express agreement. And I think, that type of procedural mechanism, for example, concurrent hearings, and being able to facilitate that, I think potentially is an answer to kind of, these cases where there's an overlap in terms of, jurisdiction. If we can have a concurrent hearing, even if it's two different arbitrations, like we can reach a result that's more consistent at the end.
And that's at least you're ensuring the same evidence as before both tribunals. Exactly. And that's a fairly that will be a fairly common mechanism to a lot of our listeners in the world of international trade, whether it's kind of GAFTA related or LMAA related. But the idea of concurrency being a feature of international trade arbitration or a specific international trade arbitration bodies, and often that's because of these contractual chains of sale or contractual chains of charters or whatever it might be. But I think you're right. It does open up the possibility of having the same evidence presented to the tribunal, to various tribunals in a cost-effective way.
Exactly.
Yeah. Well, interesting one.
Good one.
Yeah, I thought that was good. You don't often see, as you opened with, Derek, you don't often see a case throwing up this many kind of challenge appeal points. So yeah, good one to kick around, and thank you everyone for listening in. We hope you got something out of today's podcast, and as always, thank you for listening in, and we hope you subscribe to all those good things that help get the podcast out there in the big wide world. We're grateful for that, and thank you to our guest, Derek. Thanks for joining us today.
Thanks for having me.
Great having you on the pod, Derek. Hopefully the first of many.
Yeah, I hope so.
Yeah, exactly. Look forward to the next one. Take care, everyone.